right, the first case we're going to hear this morning is United States versus Burley, and Mr. Pender, we'll hear from you first.
Thank you, Your Honors, and may it please the Court, Don Pender for the defendant, Larry Burley. Your Honors, I would like to start with a quote. Quote comes from a different Fourth Circuit case, United States v. Friend, but I do think it applies here. And that quote is that good process often promotes good outcomes. Now, clearly I'm here on behalf of Mr. Burley because we believe that the outcome in this case was a bad one. But more importantly, we believe that the outcome was a bad one because we believe that the process was an abuse of discretion. And so what we are asking this court to do is to send this case back to the district court so that it can have an opportunity to perform the proper analysis. If it were to do so today, it would have the benefit of an actual policy statement from the guideline, which I think would clear maybe some of the court's confusion, or maybe clear some of the things the court seemed to be of the opinion it didn't need to address. It would now know exactly what it needed to address. It would also have the benefit of more robust case law that has happened since McCoy. In looking at the opinion, and I think that's where you have to go, is to the record in order to determine what the district court did here. It's our opinion that the district court, while it acknowledged that the defendant argued that there was an issue with respect to the 924C stacking, that is a different question from whether or not the court considered it. And I think when you look at McCoy in particular, McCoy makes it clear that there are two distinct features when you're looking at a 924C stacking case and assessing extraordinary and compelling circumstances that you ought to look at. That's the unusual length of the sentence, and that's the gross disparity that's created. And so it's not enough to simply acknowledge that the defendant is arguing that his sentence may be longer. And in fact, that is language directly from the opinion, that he may have a longer sentence today or that there may be a disparity. There is no may, first and foremost. It's without question. He received a 45.5-year sentence. 35 years of it is based on a 924C stacking provision. It's no longer valid. He would get 20 years mandatory on that today. So we're talking about a difference of 15 years. We're not talking about a difference of 15 months or 3 years or even 5 years. We're talking about a significant difference. We're talking about a difference that is actually the statutory maximum on the carjacking charge that he was charged with. And so for the court to go through the entire opinion and not at any point acknowledge the sheer and unusual length of the sentence, the gross disparity that is created when those 924C charges are unstacked, as they would be today, that is the first place where we would say there is an abuse of the court's discretion. There's also exceptional rehabilitation in this case to the tune of 6 letters from BOP officials, many of which say they believe Mr. Burley could be released and would be an asset to society right now today. I would note that that's notable. It's notable for a couple reasons. One, it's notable because, again, these are BOP officials and these are folks that work with Mr. Burley regularly. But also it's exceptional because, again, remember, he was never asking for the court to, or at least once his formal filings were made, he wasn't asking for the court to reduce his sentence and release him immediately. What he just asked for was for the court to reduce it by the 15 years that any defendant today under these exact same facts would be subject to. He still would have to do 30.5 years. And so to the degree that the district court is concerned with promoting the interests of justice, or is concerned with deterrence, or is concerned with any of those 3553A factors, we are still talking about a 30-year sentence. And I think that's important because one of the things that the district court pointed to was the fact that Mr. Burley had only served 27% of his sentence at that time. Now, I would note that even if it went back today and he had only served 27%, that still would be more than 10 years. So that would still fit him under the new 1B1.13. But even besides that, again, he wasn't asking to be released at the point of that 27%. He would have served 30, which would have been over 50%. And so for the court to not address those things, that is where we believe there was an abuse of discretion in this case. And again, what we're asking this court to do is to send it back so that the district court could take another look at it, would have the benefit of the policy statement, would have the benefit of Brown, which came after McCoy. And I think, frankly, even
What's your
with,
response to the court's application of the 3553 factors?
I think that in this case in particular, that is insufficient. And the reason I think it is insufficient.
Statute says otherwise. I mean, statute prohibits any change in the sentence unless you have extraordinary and compelling circumstances and 3553 factors justify it.
That's right, Your Honor. Let me clarify, because I think I misspoke a little bit when I say that's insufficient. It's not insufficient that he considered 35538. His consideration of it was insufficient, and here's what I mean by that. You can't assess 3553A in this case without acknowledging, for example, the unwarranted sentencing disparity that would occur, again, because of the 15-year difference. He does not address how the exceptional rehabilitation affects the 3553A factors. He does not address the fact, Your Honors, and I think this is one of the biggest things with 3553A in this particular case is we have to remember, in order to get to this same sentence today, he would have to vary upward 15 years. The court didn't even vary upward at the initial sentencing. And so to simply fall back on what was said in 2011 in order to justify what would now be a 15-year upward variance, that's what I mean when I say his analysis of the 3553A factors was insufficient. There were things that changed that analysis.
Of course, we're not talking about a variance, and we're not talking about a variance back then at all. Mm-hmm. We're talking about a legal sentence at that point in time. Right. And a question now as to whether you can open up that sentence under the statute.
Right, and that again goes back to our assessment of the extraordinary and compelling circumstances.
Well, you have to have that, and the 3553 factors have to be satisfied.
But the 3553A factors in this particular case are really dependent upon the assessment of the extraordinary and compelling circumstances for the reasons I just named.
It's also the nature of the crime, the punishment, deterrence, and all the other factors that are in 3553A. I mean, this was a pretty serious crime, wasn't it?
Very serious.
Yeah.
Very serious, and I'm not here to downplay that aspect of it. It's a very serious crime. I would note that again, not downplaying the seriousness, there was no physical injury. And again, this is a 45.5-year sentence. I believe that is twice the national average for murder. And so, as serious as it is, and again, I genuinely don't say this to downplay it, but I do think when you're looking at the length of this sentence, you do have to consider that it is 45.5 years in a case in which there's no physical injury, which is twice the national average for a murder. And those are the types of things that this court's looked at in the past when assessing whether or not there is a sheer and unusual length to the sentence. And then again, I know I keep coming back to it, but it's why we're here. That unusual length is what creates the gross disparity. We're not arguing that it's retroactive. It's not retroactive. If it were retroactive, it would simply be a question of, is there a 924C stack or is there not one? The 924C stack is only relevant insofar as the court's assessment of whether the sentence is excessive and whether it creates a gross disparity. So I don't think you can jump over that and go straight to 3553A, and particularly where you've only addressed the same 3553A factors that you addressed the first time, and the court at least appeared to be doing that on sort of information that was now that at this point is 13 years old regarding Mr. Burley. You still have to give some consideration to what has taken place before then. That comes from the Supreme Court in Concepcion, so you still have to do that. And our position is that the district court didn't do that. The district court acknowledged to some degree that there had been some rehabilitation, but really gave no indication of how that rehabilitation affected 3553A or affected the extraordinary and compelling circumstances analysis. In fact, the language regarding that rehabilitation in the extraordinary and compelling circumstances portion of the opinion is just outright wrong. The district court cites a case that says rehabilitation alone is insufficient. Well, the defense was never arguing rehabilitation alone. No one was ever asking the court to consider rehabilitation alone. It was rehabilitation along with the gross disparity, along with the age of the defendant at the time of the conduct. The age of the defendant probably is, of those three, the least strong, but they are all to be considered together, and it also does not appear that the district court did that. One of the most glaring things I see here is that the district court read McCoy, seemed to just kind of pull out the portions of McCoy that spoke to its discretion to make the decision it wanted to make, but ignored the holding in McCoy, ignored the analysis in McCoy, ignored the analysis in all the district court cases that McCoy cited. Even going back to look at McCoy when it was at the district court judge, I mean, he didn't spend, there's not, you know, a super robust analysis of the gross disparity, but there's enough there for us to know how the district court felt about it. I think the problem here is you could read this entire opinion and not actually know if this judge found that there was a usual length of this sentence or whether or not he found that there was a gross disparity. And I think that's a problem when you can read the opinion and not know where he comes down on those things. At minimum, we need to know that because, frankly, it's hard to see how a person, if they've conducted the process correctly, could look at a case like this and come to a conclusion that a 15-year disparity is not dramatic. Now, the court may go do its 3553 analysis, and that will lead to an outcome. And you know, whatever that outcome may be, if it is sent back, will be addressed or not addressed when that time comes. But I think first things first, the court's got to get the analysis right, so that if this court is in fact reviewing it, you know where he stands on it. So
Is that it?
that is, Your Honor.
All right, thank you, Mr. Pender.
Thank you.
All right, Mr. Kapoor.
Good morning, Your Honors, and may it please the Court. Vatan Kapoor on behalf of the United States. The District Court did not abuse its discretion by denying Mr. Burley's motion for a sentence reduction. The District Court did not act irrationally. It followed the statutory parameters, and it conducted the necessary analysis. Ultimately, Mr. Burley disagrees with how the court weighed the brutal nature of his crime, his history, against the rehabilitation evidence that he presented. But that disagreement is insufficient to reverse the district court's decision. It may be true that different judges, different courts, maybe even this court, would consider reaching a different conclusion under the same set of facts, but that's not the standard. The standard is in whether, arriving at this decision, the district court abused its discretion. It did not. I'd like to start with the McCoy and the stacking argument. Mr. Burley's argument relies on a fundamentally flawed premise, that it was only due to the then existing mandatory minimum that Mr. Burley received a 545-month sentence. In fact, the district court's opinion makes clear that the basis for the sentence was the brutal nature of the crime, the lifelong impact on the victim, on the victim's wife, his criminal history, and the fact that he was on probation at the time when he committed the crime that were the bases for the judge's sentence. In fact, at the original sentencing hearing, the district court said that it very nearly varied upward and considered sentencing the defendant to life for the misery that he inflicted upon the victim. And I understand the point of comparing statistics to, national averages for murder and national averages for other crimes, but the facts of this case show exactly why district judges need to retain some discretion to consider the facts of the case, the victim impact, and come up with a sentence that's appropriate to what happened in the crime and the circumstances of the case. During the sentencing hearing, and the reason why the 2010 sentencing hearing is important is because the victim testified, his wife testified, and this is the same judge who is considering the compassion release motion. The victim's wife said that he's not the same man she married. He's scared, irritable, jumpy. His happiness has been replaced by a vacant stare. He can't watch TV anymore. He can't go outside anymore. So yes, there might not have been physical violence, but when you shove a shotgun down a man's throat, when you threaten his family's life, when you threaten his wife's life, you threaten his life, you're driving around all night, robbing banks, he doesn't know if he's going to live through the tale. The government would argue, Your Honor, that is a significant crime that the district court probably remembered. When this came back up, the district court probably remembered being in that room listening to the testimony of the man who was robbed, the testimony of his wife, and appropriately considered that. But in any event, the district court expressly acknowledged that it had the discretion under McCoy to find that the amendments to the First Step Act could create an extraordinary and compelling reason for release. But the district court cited the panoply of considerations, including the egregious nature of the crime, the victim impact, the defendant's criminal history, as its basis for concluding that in this case, it would decline to exercise its discretion to find that the stacked sentences were an extraordinary and compelling reason for release. In other words, from both the sentencing, over a decade ago, and from the record as described in the district court's opinion, we know why the district court believed that the stacked sentences were not extraordinary and compelling in this case. I just want to also touch on the fact that if you were to accept Mr. Burley's argument here, functionally what we're saying is that there are some cases where a district court cannot exercise its discretion in finding that there are, notwithstanding a stacked sentence, there are reasons why the stacked sentence shouldn't be an extraordinary and compelling reason for relief. The government would argue this is precisely the type of case for which the discretion that McCoy offers matters. And I'll just turn to the failure to address the sheer and unusual length of the sentence. This court in Moody, which is a case that was decided last year, said that a sentencing disparity alone can't dictate a court's analysis. Rather, the court must make an individualized assessment of the defendant's sentence and give full consideration to the defendant's individual circumstances. And that's precisely what the district court did here.
You haven't said he had, nothing you mentioned at all is really referencing considering it at all. You just had one side of the equation. And I understand why you did. You're right, it's a serious case, and I don't understand Mr. Pender saying that it wasn't. You recited all those things that were how the crime is, but McCoy requires a balance of consideration. The brutality of the crime, you're right, will never change, but human beings do.
Yes, Your Honor.
And that's what McCoy says. You have to balance that. And the question is, Mr. Pender started off, he didn't say, well, you can't do that. You don't have discretion to do that. You can't end up, but you do have to do the balancing that's required. And there are some extraordinary things here when prison officials write letters like that for people who've been in prison for a long time. That's pretty extraordinary. I mean, you have to at least say, wow, I mean, how do you balance that? What balances a bushel of wheat against a heart full of sorrows? There must be some balance. I mean, that's what it's saying. He didn't say you couldn't do it in the discretion, and I know you did. You made a good argument in terms of what happened at sentencing. But things happen afterwards. Like the Sentencing Commission, they looked at the unfair stacking. It was there for that. All cases, not just this case, but all of those, and some of them are serious. But tell me, where's the evidence that he balanced the other side of it? You gave the equation very well, and nobody's arguing with it. But what about that, the letters and consideration? What did the court say about those letters?
Yes, Your Honor. So I think a fair reading of the district court's memorandum.
About the
order-
letters, that's my specific question right now, about the letters from BOP.
I don't believe that the district court specifically mentioned the
answer's nothing.
letters in the memorandum order, but it did specifically and in detail consider the categories of rehabilitation evidence that Mr. Burley provided. For example, he noted the involvement that Mr. Burley's had with the church, his completion of multiple drug courses, that's at JA 196. He noted that the staff members at Florence have attested that Mr. Burley is, quote, a hard worker, dependable, and can now do well in society. And he also formally wrote the victim an apology, and that's at JA 197. So the district court did go through the specific evidence, but came to this conclusion that, while the court commends him for his good behavior, the rehabilitation ultimately, quote, does not outweigh the factors discussed above. So at least with respect to the 3553A analysis, what the district court is saying is, I've looked at these specific pieces of information, what the staff members attested to about his positive steps, his going to church, his going to the drug abuse programs, that he wrote the victim an apology letter. But in the district court's mind, it weighed that against the heinous nature of the offense, the criminal history, and in the district court's mind, the rehabilitation evidence simply didn't outweigh those factors. And the government would argue that that's precisely the kind of balancing that a district court has the discretion to engage in, even if similarly situated judges would come to a different conclusion. And I'd also note that this is
Then McCoy would mean nothing, really, then. You're saying that no matter what he did, he could have saved 5 people's lives in prison, discovered a cure to cancer. Whatever he did, as long as the district court said this crime was horrible, that's enough for me, that's enough, right? Would it not be?
no, Your Honor, that's not.
What would temper the discretion of the courts just to say, no, I saw the crime, I know what your history was, I know what you did, I know the impact was, none of that will balance it. What would be the jurisprudential restraint at all in terms of carrying out McCoy if that's the metric? Just to identify, yes, you did do this thing. I recognize that it's in your record, but not really doing it and weighing and balancing. For example, isn't future dangerousness an issue in terms of 3553A?
Yes, Your Honor.
Wouldn't it calculate that people are saying these things about someone who's in prison for that long and having a record like that and being commended, have some positive aspect? Is anything in the record that argued in his behalf?
Your Honor, our read of the court's opinion is that at JA 196 to 197, the district court does address Mr. Burley's conduct while in prison, the fact that staff members at the prison have thought positively about him. The case law is clear that the district court's not required in its opinion to articulate every single, point by point. So we would say that if you look at the discussion of the rehabilitation evidence.
That's not discussion, that's just listing things. I mean, a list, enumeration does not equate with discussion and consideration. Doesn't equate necessarily. You say, okay, well, that's that's all in there. I mean, doesn't it take more than that? Some sense in that? Is there any discussion that impacted like his lack of? Well, let me ask you this question: do you think behavior in prison and those things like that impact positively the question of whether or not you're future dangerous? No matter what you've done in the past, does that speak positive about the reduction in your dangerousness in the future? Does it?
Yes, Your Honor.
Did you see the court noted that at all? Give any kind of consideration positive for that at all?
So-
I didn't. Maybe you did, but where?
So again, Your Honor, I think the record would give the government comfort that the court considered it, whether the court expressly said, and, addressing
You're
future.
selling the court short. I mean, the court spent an entire paragraph discussing his rehabilitation, encouraged him on it. It acknowledged the letters of the prison. It acknowledged that he's turned his life around and all that, and it says that's not enough alone. It went through every one of the factors that he raised: age, stacking and rehabilitation, and devoted an entire discussion in each one, and then said the 3553 factors outweigh that, and pointed to the fact that the victim was permanently injured for the rest of his life and this type of thing. And I don't understand why you won't back the judge up on that, because he even mentioned the letters. He also mentioned the fact that the man applied to the warden to ask for discretion, and the warden turned him down. So there was a lot of balancing. It was a very thorough discussion that the court gave in connection with his sentencing.
Yes, Your Honor, the government agrees, and
We
to be
don't
clear,
normally see it this complete.
to be clear, the government is standing behind the district court's memorandum order. I just want to, if I may, Judge Gregory, address your question about sort of the parameters around abuse of discretion. I think contrasting this case to Malone presents a really good opportunity to describe what an abuse of discretion is. I mean, in Malone, the defendant was 68 years old when he filed his compassionate release motion, had multiple surgeries relating to colon cancer, was in fact, on home release, ordered by the BOP at the time. And it was in that context that district court abused its discretion by finding that the defendant's advanced age and medical circumstances were not an extraordinary and compelling reason. So again, we're not saying that any particular types of rehabilitation evidence could not weigh favorably in favor of a sentence reduction. It's just when you look at this record, you can see the judge has considered the rehabilitation evidence presented, weighed that against the seriousness of the crime and the defendant's criminal history, and exercised its discretion saying, I don't think a sentence reduction is warranted at this time. One other thing that we'd point out is that the district court noted that at the time of his motion, Mr. Burley had served 27% of his sentence. The reason why that matters, and this court in Kibble said that the courts can consider the amount of time served, is because things like rehabilitation over time can present stronger and stronger evidence of things like a reduced risk of dangerousness. So we would argue that shows another way in which the district court was in fact considering the positives against the negatives and saying, look, you've served a quarter of your sentence at this point, but there's this positive rehabilitation evidence. Based on all of that right now, these factors don't outweigh the dangerousness as reflected by the seriousness of the offense and the criminal history of the defendant.
What about the discrepancy in terms of the sentencing now that stacking was done? And the court did utilize stacking to get to that because it had no choice at that time, right? The stacking increased the sentence, and that stacking would not be in place today, correct?
Well, Your Honor, the court would have had a choice. The court could have varied upward. And again, the sentence that was imposed in 2011 was done in the context of what the sentencing guidelines were there.
Like I said, it did use stacking, did it not?
Yes, Your Honor,
it did.
But it did also make clear that it very nearly upward varied and sentenced the defendant to life. And we would just point out again, if we were under the guidelines and the parameters as they exist today, the government's charging decisions, the government's plea negotiation decisions, and the court's sentencing decisions would all be taken in light of the guidelines that existed today. So I think, again, you can look at what the district court actually said in the sentencing in 2011, and it's clear that this sentence wasn't, the 545-month sentence wasn't a but-for kind of sentence. In other words, but for the mandatory minimums, the court would have been imposing a much lower sentence. Rather, the court was considering imposing a much higher sentence, but then ultimately decided, viewing the totality of the circumstances, that 545 months was appropriate. So it's in that context that we're saying this case is a little bit different from McCoy or Brown, because the difference in the mandatory minimums is not playing as significant a role in the actual determination that the sentencing judge is making. I just would like to address a couple more arguments that Mr. Burley makes. One, he argues that in the extraordinary and compelling analysis, the district court erred by considering 3553A factors. We'd urge the court to make clear that even in McCoy and since, this court has made clear that that's exactly what a district court's supposed to do. When you're explaining why a non-retroactive change in mandatory minimums doesn't create an extraordinary and compelling reason for a sentence reduction, you have to necessarily refer to the reasons why it's not an extraordinary and compelling circumstance, and those reasons include the nature of the offense, the criminal history, and those are sorts of things that the district courts in McCoy expressly relied on. So if the court has no more questions, we'd ask that you
All right,
affirm.
thank you, Mr. Kapoor. Mr. Pender?
And I'll just touch a couple things. I do want to make clear that it's not our argument today, nor was it then, that the conduct here wasn't serious. And I think that there's not any getting around that. And I want that to be clear on the record. The conduct here was extremely serious. And I'm not saying it wasn't. My only point is that that exact same conduct today, as he pled guilty to it, the mandatory minimum would be 15 years less than it is. So that exact same conduct today, a defendant that came before the court, his guideline would be 2 10-year 924Cs, and then I believe it was 90 to 125 months on the carjacking. I don't quite understand the courts, and even to some degree, and this is not a personal thing, even to some degree the governments, I don't quite understand this sort of dancing around that. I mean, there's that part is
The
not.
law, there are a lot of people serving sentences under different types of arrangements that Congress makes, and the changes sometimes are made retroactive and sometimes not. But we're talking about compassionate release, and compassionate release has to take into account all these factors, including the 3553 factors. The court spent a lot of time on both the positive and the negative. I don't understand why the court didn't give everything full consideration. The only question is, would we have decided it differently? That's not the test. The test is whether the court abused its discretion. And the court explained what it was doing. It addressed the stacking, recognized it. Well, it stacked again. I mean, even under the current, there's stacking. Stacking's the wrong term. It reduced the reduced sentence for it, for the stacking of the two violations. So the court acknowledged that. The court acknowledged his age and addressed that. The court acknowledged his, these are separate discussions, acknowledged his restoration in prison, his good works, and procedurally went all through that. But then the court says under the 3553 factors, they're not outweighed. I don't know what else we ask the court to do except to disagree. And I'm not sure we're free to, are we?
Your Honor, I think to your point, and I think where I may differ on that is, there's no disputing that the district court, said the words that it needed to say. It said.
What else is it going to do? It's say the words. It said all the words. It acknowledged, not only acknowledged these things, it commended this man. But, and it said, we expect this. We hope we're doing it. It commended him and encouraged him. We talked about the letters, but it also talked about the fact that he asked the warden to file a motion, and the warden refused to do so. So, I mean, the court covered just about everything. And I don't understand why you would say that in this fairly lengthy opinion, sentencing opinion, that the words don't mean what they say.
Your Honor, because the 924 simply saying that, the court simply saying that it acknowledges that there was a 924C stack in this case.
But you have to go against the background that Congress said no sentence can be changed unless we authorize it under certain specified circumstances. So even though their sentencing level may have been different then than it is now, we don't change sentences unless, and then it sets a criteria. And that's what we're here under compassionate release. And the court went through the compassionate release. We have said that either prong, either you can find exceptional circumstances or the 3553 factors you can address. Either one justifies a court's discretion. And in this case, the court addressed both. I don't know what else the court should say. I mean, tell me what the court should say differently.
The court should acknowledge or at least address whether or not this sentence was of an unusual length and whether it constituted a gross disparity. That is the extraordinary and compelling
It did
circumstances.
address that. It addressed it explicitly.
Your Honor, it never even says the words.
It doesn't
it
use
never
gross
says-
disparity. It acknowledges the
And I know,
substance.
I'm sorry, I didn't mean to speak over. I mean, it's not, we're not talking magic words, and Your Honor, before I go forward, I'm about out of time. Can I finish, at least finish this point? Would that be okay?
Yeah, please, sure, of course.
Your Honor, we're not talking magic words, and I understand that. So it's not as simple as looking through this and saying, did you say the word gross disparity? Did you say the word sheer and unusual length? Did you say the words exceptional rehabilitation? I understand that. But what I am saying is, when you can read an opinion and all you can come away with as to his analysis of the extraordinary and compelling circumstances is he acknowledges that there's a difference in the 35-year 924 stack then and the 20-year 924 stack today. A mere acknowledgement of that is not addressing the argument. We have to know whether or not, in this court's view, that constituted a gross disparity. We need to know whether or not in this
Where
court,
do you
in the
find gross
district courts.
disparity in the statute that the court had to consider?
Well, I do think, given at the time, I don't think that was there, but I do think McCoy makes that
That's not a
clear.
requirement. All you have to do is consider it, and the court recognized the fact that the sentence under the stacking sentences back then were larger than the stacking sentences currently in place. And the court says, but it's still justified because, and it went through then several pages of discussion why. And so it seems to me that is what sentencing is about, addressing all the issues and balancing them and coming to a conclusion. I don't understand what words we should disregard because they're just spoken by the court.
Well, Your Honor, and I'm quite a bit over now, but if I could address that.
Sure, please do.
I'm not necessarily saying you need to disregard anything that the court said. Really, what I'm saying is that the court, in its reasoning, didn't say enough. And I think it
Well,
goes
what more
back
should
to
it say?
weighing, well, it needed to weigh, for example, the exceptional rehabilitation.
It expressly weighed. It addressed separately every one of your points. You made 3 points. It addressed every one of them, and then said, but in this case, the 3 factors outweigh that, and this is the reason why. And then it explained why.
But, Your Honor,
What more should it say?
even to the point you just made, you said he addressed them separately. I mean, one of our points is, again, they're supposed to be assessed together. So that is yet another error that we're kind of pointing to here, is you have to give some sort of real analysis of the arguments that are being raised here. Simply just listing them and saying them back to the parties is not giving a true analysis of that. I understand the court's point that he did address them.
My point is basically, this is a fairly lengthy sentencing memorandum. It's thorough. It addressed everything that the court had before it. It said everything on the court's mind. I'm just not sure that we should be telling the court they should say something else. The court said why it exercised its discretion the way it did. We may not agree with it. I mean, if I were the district judge, and I was one for a short time, I might reduce it to 365. I think that's what you would want, is the 240 plus 125, right?
That's right.
Right. I might have done that, but that's a discretionary decision. This court explained why it did it, and it was moved by the enormous victim damage, in this case that's everlasting, and the fact that the sentence was an appropriate sentence, recognizes rehabilitation. The issue in this case, and you didn't raise this, but the issue in this case is not whether the court expressed himself. The court, you raised 3 issues about disparity, age, and the rehabilitation. And every one of those 3 was addressed fully. So now the question is, all you can do is disagree, and I know you do disagree with the court's statements on those 3 points, but was that an abuse of discretion if the court looked at it that way?
I think the abuse of discretion comes where, again, and I've noted several places where I see it, but I think even in talking about the 3553A factors, in my view, the abuse of discretion comes in the reliance on just that single factor and the failure to weigh any of the other
The
things.
court recited 3 or 4 factors.
But not in the context of how they affected 3553A.
Yes,
For
it
example,
did.
the court doesn't
It
say.
talked about protecting the public, deterrence, and all the, whatever it said there on the factors.
It did, but those almost all go to punishment. I mean, there's no discussion of, for example, the unwarranted disparity. I don't know how if I could put it this way, if this were to go back and we were at a sentencing and I was arguing to that judge at a sentencing hearing, and I said, Your Honor, this is an unwarranted disparity. A person today would get a guideline of 30 years and
Well, of course, unwarranted
5 months.
disparity doesn't compare past people with future people. It compares sentences imposed at the
That's-
time the
that's
sentence
fair.
was imposed.
That's fair. But if I were to say this 45.5-year sentence is an unwarranted disparity with similarly situated defendants today, which it unquestionably would be, that goes back to what I was saying before, which is that the district court would then have to give a reason for why a variance of upwards of 15 years is sufficient in this case. Simply restating the conduct for which, again, this same conduct, these same facts, a defendant
Look,
is
it
subject to.
recited the conduct, but it also recited the effect of that conduct on society and
And
the
on the
lasting
individual.
impact and its permanence.
Yeah.
I mean, those are factors that go beyond just the conduct.
Those are
I mean,
also.
The question is, what is the appropriate sentence on the motion for compassionate release? And the court reassessed the entire sentence, both the reasons you gave on the one prong, the extraordinary and compelling circumstances, and the second prong, the 3553A factors. And it did both. It didn't have to do both. We've approved sentencings where just the 3553 factors have been proved, or where the court simply said there was no extraordinary and compelling circumstances. But here the court did both, and then explained why it was doing what it was doing. Now, I think you can legitimately disagree because of the things you're saying, and your arguments are persuasive, but we're talking about an abuse of discretion. That's sort of, you basically have to say the judge went off the deep end somehow.
I think.
I'll give you 30 seconds to wind up, because I've gone over here.
I think the judge went off the deep end when he did not seem to consider the holding, the reasoning, the analysis in McCoy at all.
Okay.
And that was all that he had at that time.
Thank you very
If it went back,
much.
he would have.
We'll come down and greet counsel and then proceed on to the next case. We'll proceed to the next case, United States versus Johnson. And on this case, we'll hear Mrs. Bechara, is it?
Good morning, and may it please the court. Jacqueline Bechara for the United States. In 1999, the defendant was sentenced to life for his role as the leader of a violent drug trafficking conspiracy. If he were sentenced for his crimes today, he would still be subject to a mandatory life sentence. For that reason, the district court abused its discretion in finding extraordinary and compelling reasons to reduce his sentence based on intervening changes in law and policy that have no practical effect on his sentence, as well as based on the disparities between his sentence and the sentences of his cooperating co-conspirators. Because his remaining claims do not rise to the level of extraordinary and compelling, the court should reverse. In this court's cases, where the court has upheld the finding of extraordinary and compelling reasons based on intervening developments in law, the crux of the court's reasoning was that the change in law would have some effect on the defendant's sentence if he were sentenced today, right? We think about cases like McCoy and cases like Brown. But here, turning first to the 924C sentences, the district court relied on two intervening changes, right? The First Step Act's amended penalties for multiple violations, as well as the Robinson memo. But regardless of how those changes might have affected the 4 consecutive 924C sentences, they have no practical bearing on the sentence the defendant would actually serve, because those run consecutively to 2 life sentences, one of which remains a statutory mandatory minimum today. For similar reasons, the fact that the defendant was sentenced before Booker under the mandatory guidelines is not an extraordinary and compelling reason to reduce a statutory mandatory life sentence. In other words, even under the advisory guidelines range, the district court would have no discretion but to impose a life sentence for the Vicar murder conviction.
So what we, the district court gives a bunch of reasons why he granted the relief in this case. There's no, the government doesn't say, because there's a mandatory life sentence, that compassionate relief was not available.
No, that's not our position.
So we don't have, that mandatory minimum isn't a bar. So why isn't, the factors that the court considered enough that the court's acting within its discretion?
Because, so, our position is that if a defendant could establish proper, extraordinary, and compelling reasons, certainly the statute authorizes a district court to reduce even a statutory mandatory minimum sentence. The problem here is that even McCoy says the defendant still has to meet that statutory standard of extraordinary and compelling reasons.
So
And if you look at the...
Is your argument a categorical one, that if the defendant would be sentenced under the same thing today, that's a categorical bar to extraordinary and compelling circumstances?
I hope I'm not making a categorical argument. I'm saying that in this case, these sort of intervening developments that he has identified are not extraordinary and compelling with respect to his sentence. If you look at the text of 3582C1A, it contemplates that the extraordinary and compelling reasons are going to be tied to the term of imprisonment that is reduced. And here, there's simply no connection between all of these things that he has identified and the life term on count 5. That's the problem. That's the issue, or our problem with the district court's analysis, is that they're all sort of tangential to count 5.
But back to the statutory language, I understand your argument. I get it completely. I guess I'm just trying to figure out how we know, what's the rule we're doing here? Extraordinary and compelling circumstances, is it, if your argument isn't that there is no practical effect of the change and therefore you can't have it, I guess why is it not appropriate to consider it?
So I'm not saying that the district court couldn't consider it. I'm saying that it doesn't satisfy the language of extraordinary and compelling. The 5 other circuits that have interpreted just the plain statutory language, since those words aren't defined in the statute, have said we give these words their plain meaning, right? So extraordinary has to mean something that's unusual, that is not common, that lacks precedent. And I offered the analogy in our briefing of cases where the court has said, okay, even problems defects in consecutive 924C sentences, either on direct appeal or for defendants seeking 2255 relief, the court doesn't disturb those sentences because the reality is that the defendant is never going to serve those consecutive 924C sentences because he will be serving his life sentence. That's the point that I'm trying to get at here.
In
Again,
other words, you're saying that he receives 790 months imprisonment consecutive to his life sentence, and that the elements of the compassionate release argument are addressing the 790 months and not his life sentence.
exactly. Yes, you've said it better than I could, Judge Niemeyer. I can
Does
talk.
that change the discretion of the court? The court has discretion to grant compassionate release, correct?
Within the statutory language, yes, Judge Gregory.
Within the language is in terms of whether or not the court feels there's extraordinary circumstances, right?
Right, but
The court
McCoy
has
says,
discretion, does it not? Well, we can't have it both ways. It come with that, you know, the court, when the court says you don't get it, it's fine. But now when the court, in a rare circumstance, is granted, now it's picked through, it's wrong now, it's different, the goalposts change. The court gave compassionate release here. I mean, why is the government, it's like Shakespeare would say, "Thou protest so much, too much." I mean, you said it doesn't mean anything, so why is the government here? It must have meant something. The court felt there was something that compassionate release in terms of compassionate consideration was important. If it wasn't, why are you here? It means nothing. Why is the government wasting time for the court to be here if it meant nothing to him?
I certainly don't mean to waste the court's
I didn't say,
time.
but are you arguing, is your argument saying that this doesn't matter?
No, not at all. This
It
case,
did matter, didn't it? It does matter to him.
certainly, it mattered to the victims of these crimes.
No,
And
don't-
we
no,
are,
no,
we are,
we're not, we know the victims of the crime. Compassionate release knows, compassionate release was not there because there's something wasn't done wrong. It's in the sense that it's release for compassionate release, I mean, for reasons. Yeah, but does it mean something? I thought you were saying that it didn't make any difference in this case at all to what time he would ultimately spend. Are you saying that? No, you're not saying that, right?
yes.
Guess what?
The reasons that he identified have no practical relevance to the sentence he will serve. The reason the government is here is because we maintain the district court abused its discretion in finding extraordinary and compelling reasons. We know from McCoy that, yes, the district court has discretion in assessing a motion for compassionate release, but that discretion is bounded by the terms of the statute, which is a limited sentence modification statute. I can address briefly the claim about co-defendant sentence disparities, if that would be helpful. It's well established in the Supreme Courts and that this kind of claim of sentence disparity between a defendant who went to trial and his co-conspirators who pleaded guilty is not an extraordinary and compelling reason for a sentence reduction. We maintain that the disparity between Mr. Johnson, the Parenti twins, and Eldon Brown is not unwarranted because they cooperated, they provided substantial assistance. On direct appeal, this court would say this is not an unwarranted sentence disparity, and so we maintain for similar reasons this doesn't rise to the level of an extraordinary and compelling reason to reduce his sentence.
Counsel, we may be bound. You mentioned the cases that you talked about. I think you're right on that. It does strike me as odd whether we can do anything about it, though, that a defendant exercises a constitutional right to have a jury convict him beyond a reasonable doubt, and therefore he's legally in a different place. Anyway, that's just, that may be foreclosed by precedent, but, you know, you have a view on that?
I appreciate
from
that,
the
the
precedent.
court's concern. I'm sorry to interrupt you. I appreciate the court's concern, but again, the Supreme Court and this court have made clear that's an ordinary feature of the trial and sentencing process, and it would be quite disruptive to now use post-conviction motions to upset settled expectations about plea bargaining and cooperation. I mean, this would disincentivize defendants from cooperating with the government, and as I'm sure you can imagine, especially in cases like this where you have kind of underground drug trafficking and crimes of that nature, our case depends on our ability to secure cooperation. If defendants know that that's going to be a basis to get a sentence reduction, or I'm sorry, not cooperating is a basis to get a sentence reduction, I mean, that upsets normal incentives in the criminal justice system. So I would strongly urge the court not to uphold the district court's ruling on that front. So the last aspect that we have to cover are the defendant's age and rehabilitation. As we stated in our brief, once you sort of strip out the improper factors, we maintain that those are not enough to meet his burden of establishing extraordinary and compelling reasons. His age was relatively common for defendants convicted of violent offenses at the time, and of course he was not a juvenile when he committed these crimes. And then his rehabilitation, although it could factor in as one among other factors here, because the other factors are really not proper considerations, that can't meet his burden in this case.
Is that it?
Hearing no further questions, I'm happy to reserve the remainder of my time.
All right.
Thank you.
All right. Mr. Wenstrup?
May it please the court. Good morning, Your Honor. My name is Nathaniel Wenstrup for Mr. Shaheen Johnson. After multiple rounds of briefing and hearing
Could you
in
keep your
court-
voice up, please? We're across the room.
Thank you, Your Honor. After multiple rounds of briefing and hearing in court from a victim's family, from Mr. Johnson's daughter, Mr. Johnson himself and counsel, the district court in a 32-page opinion reduced Mr. Johnson's sentence to 35 years. Obviously, this court refused these compassionate release cases for an abuse of discretion, and while I was going to use the terms arbitrary, irrational, or unreasonable, I think I'll invoke the court's language that the court would really have to find that the district court went off the deep end in this case. It did not. So this is not a resentencing like under 22.
Well, the question is, I think everything was properly before the court, but the core reasons where the circumstances have changed, their stacking was changed, Booker was changed, and let's grant those. Those would then reduce the 790 months. The government's position is, okay, take away all the 790 months. Don't just reduce it, you can even take it away. It's immaterial to the fact that the sentence remains, the unattacked sentence remains today mandatory life imprisonment or death. Those are the two options only that Congress gave for this crime. And the lower end of that requirement is mandatory life. Now, the question is, if that sentence was not attacked by Booker and stacking and so forth, then the court shouldn't rely on factors addressing the other sentences, the stacking, in order to reduce a sentence that was not changed and clearly not changed and is mandatory. That's the government's position. And so it's really sort of firing your weapon, proper weapons, but you're aiming at the wrong thing.
So I appreciate that, Your Honor. I think that, as Your Honor says, I think the court was very specific in outlining its methodology, that it looked at the subsequent changes in the law as extraordinary and compelling reasons to reduce those sentences. Then it moved on to count 5. And while I believe the government is saying that they're not asking for a categorical rule, really what they seem to be arguing for is a categorical rule.
It doesn't matter how you call it. The question is, the attack didn't go to that sentence. That sentence remains the same.
Yes.
The sentences that could be reduced if presented and discretion were exercises were the 790 months. And the 790 months, the government says it doesn't matter how much you want to reduce it. If the court wants to reduce it, fine. He still gets the mandatory life, which was not addressed by those factors. That's Congress's demand. And so the reduction of a mandatory life sentence has to fit the criteria set forth in the statute, not the other sentences. That's the argument. And I'm not sure, it's not the improper factors, it's the misdirection. It's applying factors that normally can be considered in compassionate release, but it's applying them to sentences that are immaterial in this case, because it's hard to serve 790 months after you've served a life sentence.
Completely agree, Your Honor. But I think that the district court was clear in its methodology that in looking at count 5, the mandatory life sentence, that's where it was looking at three factors that were absolutely permissible and relevant. It was looking at the sentencing disparities. It was looking at youth, the role of youth in the conduct here, and it was looking at rehabilitation. And I think count 5 specifically.
It really comes down to rehabilitation, doesn't it? Because the youth, he was 24 years and 10 months, and the argument you would make is he's not mature until he's 25, 2 months later.
So, Your Honor,
If you based elimination of a life sentence, a mandatory life sentence, on the fact that somebody is 2 months short of what people believe the maturity of a brain is, that in and of itself would constitute abuse. So you're really left with a serious contention on rehabilitation. That's a good contention. But the question is now, both Congress has indicated you can't rely on retention. You have to have other factors, rehabilitation. And case law says that too. That's pretty universal. It's a factor that may be considered, but it doesn't justify it.
yes, Your Honor, and I think the government did not seem to contest at all that
That's right.
the rehabilitation was extraordinary.
Yeah.
And in terms of,
I think the record demonstrates it. I think there
Yes.
is that. And I must say, just as I've said many times in different contexts, I think there is a lot of glory for prisoners who genuinely redeem themselves in prison. I think they deserve a lot of human praise and commendation, and they should be encouraged. The question is, to what extent do we change the laws that were applicable to their crimes? And it's a factor, but
yes, Your Honor.
and we're very glad for the rehabilitation, I must say.
And thank you, Your Honor. And I think that, it's also of note that the rehabilitation came here after all of his appeals were up, when he essentially had no hope of release and kind of showed himself to be a new
Counsel,
person.
can I try to dig into this a little bit? Do you, it sounds like you're recognizing that the changes, that the Booker changes, the memorandum changes, and the stacking law changes, I want to see if I'm understanding you right. Do you agree that those are not extraordinary and unusual circumstances with respect to the murder conviction?
With the mandatory life, I think that I think, yes, I would agree that they are very far from the prime drivers. I think in the court's reasoning, I think what it's saying, in my reading, is that those subsequent changes in the law are are extraordinary and compelling reasons for the 924Cs and for count 2, and because of the ambiguity the Booker application there. I think that when the court is looking at count 5, it's really looking at the extraordinary and compelling reasons being sentencing disparities, the youth at the time, and rehabilitation. And I think it's important to take a look at the specifics of count 5, because there, Mr. Johnson got a mandatory life sentence for his involvement in the death of Mr. Villa. And I think the jury specifically found that he had a relatively minor role in the death of Mr. Villa. And so I think that those facts.
That is way beyond the sentencing court's discretion of any kind. Once the jury finds a violation of count 5, the court is bound.
Oh, absolutely, Your Honor.
And so we can't argue whether the jury justified it or whether that's a mitigated sentence. I mean, that sentence cannot be changed. You have to acquit him to get him out from under that.
I completely agree, Your Honor. I think, first, the Congress did not exclude any statutes of conviction from compassionate release, including 1959, including anything else with mandatory life. So I think that is a very important note. And that kind of open-ended look at compassionate release is really our starting point.
So, but if I could just kind of finish
Yes, Your Honor.
my little, effort to get this straight in my head. If it's correct that changes in Booker, changes in 924C, and the DOJ memorandum aren't extraordinary and unusual with respect to the 1959 conviction, it seems like you almost have to say that. I mean, those, if you look up the definitions of extraordinary and compelling, it would be kind of hard to say they are there. So then we look at a reduction, and I take your point. I asked your colleague the same thing, that, it's not like 1959 is immune from compassionate release. But we're looking at disparity. That butts up to some pretty compelling, case law. So can you really do disparity when case law talks, when we have this situation about folks who cooperate? I raised a concern about that, but that precedent's there. And you have age and rehab. So is it, I guess, your position that those are extraordinary and compelling circumstances, those three factors?
I think so, Your Honor, and I think that the district court here did a very thorough examination of the record and case law in looking at those three factors, and I think that there was ample evidence in the record to support his findings. I think, starting with disparities, I don't think that that disparity case law is specifically with regard to looking at compassionate release under 3582.
Let me ask you
I
a
think
legal question, a purely legal question that rises from Judge Quattlebaum's question. The disparity, you seem to think that disparity could be addressed with respect to the life sentence. My question is, if the other persons in the conspiracy were not charged with a Section 1959 A violation, and this man was charged, and the jury convicted him, during sentencing, they could never consider that because Congress there's a mandatory minimum sentence, right? Life sentence was mandatory. There's no other sentence offered.
correct.
And so you're comparing a conviction under a statute which imposes a life sentence with a defendant who was convicted under some other statute and got much lesser offense. That's the comparison you're trying to create.
I think, yes, Your Honor, and I think the court is looking at the
If that
relative.
person were charged with the same offense, he would have received a life sentence, right? The comparator.
If he was convicted of the
Yeah,
comparator,
yeah.
yes.
So isn't that fatal as a matter of law? In other words, how can we consider disparity of sentences when defendant A is charged of a totally different offense than defendant B? Defendant B is charged with offense that Congress said they have to serve life imprisonment, and there's no discretion for the court to give him a term of years. And A, the guy was charged with some other offense which allowed for a term of years, and the court gave him a lot of credit for cooperation. How can we call either of those disparate in those circumstances?
Because I think that when we're looking at disparities in the 3582 context, like in McCoy, we were looking at.
No, we're in original sentencing now. You're standing before the court because disparities is part of the 3553.
Correct.
Unwarranted disparities. So my question is, you argue that this man should not get a life sentence. He's been convicted. He should not get a life sentence because another member of the conspiracy got X years, 10 years or 20 years. I don't know what he got, but and the government comes back and says, but the other man was charged with a different offense, not with Section 1959 offense. If he was charged with 1959 offense, he would also gotten it. So how do we compare one defendant charged with one crime and another defendant charged with a different crime?
Because I
Where
think,
the mandatory minimum is life.
correct, Your Honor. And I think that the reason is because this is not the original sentencing in 35.
No, I know. I'm staying at original sentencing now.
Yes.
My hypothetical is original sentencing, and the question is, You stand there and argue before the district court disparity. Your guy got life, and the other member of the conspiracy got 10 years.
Your Honor, I think.
Could you make that argument?
Well, I think that, one, I don't think I could make, any argument like that's gonna fall on deaf ears because of the mandatory life sentence, even making that.
It's not deaf ears, it's a question is legally, isn't it?
Correct,
Okay.
I'm sorry.
Yeah.
Is that legally, no, it's not gonna go anywhere because there's a mandatory life sentence. Also, at that point, when we're talking about, I think the case law is different about considering disparities at the original sentencing. So Your Honor is right, at the original sentencing, I would certainly get up and talk about the unfairness of the fact that Mr. Brown, who killed Mr. Villa, got a 5-year sentence for being the triggerman, for shooting and killing Mr. Villa, and that Mr. Johnson.
What did they charge him with?
I believe he was charged, he received.
What is he charged with? What statute?
He was charged with a 924C.
All right, so
I'm not sure.
924, he's got a 924C, and we have a 1959.
Correct.
924C is changed. He could even make an argument that he got too much because the laws changed under 924C and stacking or definitions of crimes of violence and all. 924C has really been amorphous. We get a lot of 924C stuff.
Yes.
But to make an argument, then or now, that a 924C conviction, sentence for a 924C conviction, is disparate from a 1959 conviction is a non-starter, isn't it, as a matter of law?
I think at the time of.
And now.
I think that this case this court has affirmed in several decisions, has affirmed district courts where they have considered the sentences of and relative culpabilities of co-defendants as part of the 3582 consideration. And so that is what we're asking here.
Say, different statutes of conviction
I apologize, Your Honor, I don't have that off the top
and
of my head.
cooperation?
I think while there is, so I think that the district court here did a very detailed look. He looked at cooperation, he looked at charges and convictions and sentences, and
Well,
looked
I
at relative.
understand that. And my only question is a matter of law. The whole disparate analysis is irrelevant because the law binds us to the life for the one person and allows a lot of discretion to move around on the other conviction, which was not only a conviction of a different statute, but a conviction of a defendant who helped the government prosecute the entire operation, which was, involved 5 murders and a lot of underground drug dealing and so forth. It's a serious crime. And so the question is, once, as a matter of law, once you have 2 persons where one is 924C and the other is 1959, can you make a disparate argument as a matter of law? And I'm not sure you can. I don't know if you have any case that does that.
I think in the 35, I don't think that there is any case law preventing this court from doing so or preventing the district court from using its discretion. That way in the 30.
Question
Yeah,
along the
that's the
same line.
answer right there.
No.
Right, the answer to the question is right there. There's nothing that prohibits it. And I think, Judge Niemeyer, if I could ask a question, one, the question is, the compassion release is extraordinary. It's nothing, there's no case law that said you can't. Judge Niemeyer asking you, well, if he's charged with that, and obviously he can't get more than that. The question is, you look at the whole idea. You talk about the trigger man, no matter what they charged him with, the disparity in the extraordinary situation is, look how little he got versus this person. And there's nothing that prevents the court from looking at compassion release. That's the issue. I mean, it's not apples and oranges, what you're being asked for in terms of, there's no case that say that. And amazing how all these guardrails come up when the court grants it, but nothing comes up, all you just say it, and it's fine.
I think yes, Your Honor, and I think as the Supreme Court said in Concepcion, the district court has vast discretion to consider basically anything that is not excluded by Congress, and I think Congress, and again, neither Congress nor the case law have excluded consideration of this kind of disparities, and so that's why I think the district court did so and really dove into all of the facts. They also looked at the average sentences, And I believe there they also considered the letter of Judge Lee. And I think that's relevant in the disparity context because Judge Lee had seen the trial. Judge Lee had seen all of the sentences. He had seen the relative culpabilities. And he wrote saying that this sentence was excessive.
Can I ask you something, counsel? Back
Of course.
to kind of what I was exploring earlier. You, I think, are arguing that disparity, youth, and rehabilitation are sufficiently within the court's discretion to justify the reduction as to the murder crime. Where is it that it's clear to you, if you don't mind pointing me, that the district court was looking at only those factors and not all the factors together? I was looking back at the order when during this, and I may not be as familiar with it right now, but it's not apparent to me that one reduction is based on those three factors. Quite frankly, it looks to me like it's based, maybe he carves out Booker for count 2, but everything else looks like it's a totality. So I wonder if we're not in a situation where, maybe we could do one thing if the court has said the 1959 reduction is for these three factors, and, we could debate whether that's within the discretion. But I don't see in the order where it did not consider the things that had no effect on the murder conviction in reducing that one. But I may have missed it, so please help me if I've missed it.
Your Honor, I was kind of looking at section I of the original.
Can you give me the J page?
I can, but I think that,
I.
I apologize.
That's all right, I'm there. I'm at I.
Here, and I think that the court is kind of walking through it, rehabilitation, relatively young, and I think that there, he kind of talks about those as totality. I think he, as Your Honor says, he mentions Booker in count 2, and then I think he's kind of goes from, he goes into sentencing disparities, and then finally the last section is he's addressing 924C and kind of talks about those kind of, and reducing those sentences on that basis alone. So there might be wiggle room there, Your Honor, but I think my reading is that he was looking at the subsequent changes in the law.
But do
And-
you agree it would be improper to consider Booker, the 924C reductions and the DOJ memorandum as extraordinary circumstances, at least to the murder conviction?
I think going back to Judge Gregory's question, I don't think that anyone has ever made that limitation, but I think that, to me, it seems like the thrust for count 5 is the disparities.
Fair, I mean, in the sense, no one said those specific words, but Congress has said it's got to be extraordinary compelling. And I think I don't want to repeat our dialogue earlier, but I think you all but said those aren't compelling, at least as to that count. So, Congress doesn't list out all the compelling and non-compelling reasons, but that is a requirement.
That's correct, Your Honor. And I think one of the things that we have here is this district court has seen hundreds of compassionate
Right.
release motions. It has seen rehabilitation. It has seen young men being sentenced.
Right.
It has seen sentencing disparities, and it found these to be extraordinary and compelling. And while I'm over time, I would just ask to speak briefly to youth and the role of youth, because I think Judge Niemeyer did mention youth, and that is a factor. But I think that the court spent a lot of time here really looking at the role of youth in this offense, because obviously youth is not a bright line, and it never has been. And I think looking at the defendants in McCoy, those defendants were 19 to 24 years old. Here, the conspiracy started at 20 and ended at about 24, 25. But I think the district court identifies that really the role of youth begins much earlier, where Mr. Johnson was his abandoned by his father. His mother was a heroin addict. He was in and out of the foster care system. He was abused and molested as a child. He was robbed repeatedly while trying to do
Yeah,
it.
but they don't normally consider that as youth. That's other factors maybe, but the youth would be at the time he committed the offense under consideration. I mean, if he had all that and committed this crime at age 32, we wouldn't even be talking about youth. We're talking about his background, but the crime committed at 32 is a decision of a mature man. So the question is here is, the 1959 was committed when he was 24 years and 10 months old. The question is that a significant youth factor to be considered?
And I think that the district court, again, at length, reviewed how, when we're talking about the 32-year-old, there's a lot more time in between, whereas this individual, Mr. Johnson, was basically, had no one left by the time he was 16 or 17, was fending for himself. Several years later, begins involvement in the conspiracy. And I think the court took all that into account, thinking about his youth specifically as a role, and its role in this offense. And I think it also looked at his subsequent rehabilitation as affirming that immaturity in youth really played a role here. In addition to that, the district court looked specifically at research by the Sentencing Commission and case law from this court talking about the youth and the role of youth, and how, you know, as Your Honor alluded to, the science is showing a longer progression of when there really is immaturity. But I think that the district court went to great lengths to show that there's never been a bright line rule on youth.
Okay. You've got some more time. No, you don't. We've gone through the red light.
All right, any further?
No, you want the court to be affirmed.
Thank you, Your Honor.
Yeah. All right, Mrs. Bitar.
Okay, I have just 3 points in rebuttal. First, Judge Quattlebaum, you correctly noted at JA 715 to 716, the district court has never said that it would find extraordinary and compelling reasons to reduce the life sentence based solely on the co-defendant sentence disparities, age, and rehabilitation. That error alone warrants reversal, if not vacator and remand.
Why is that? Let's assume, let me just ask you this. Let's assume the district court had segmented these things out differently and said, I grant compassionate release for the term he did for the 1959 based on the disparity, the youth, and the rehabilitation, and given the long explanation for that. Would you say that's an abuse of discretion?
On the facts of this case, yes, Your Honor, and I can turn to, those are actually my second and third points, so that fits well. Going back to the question about co-defendant sentence disparities, if you look at this court's cases, and of course these arise on direct appeal, but cases like Jeffrey and Susie, those involved similar claims by defendants who went to trial and argued that their co-defendants who pleaded guilty were in some respects more culpable than them. Either they had a higher role in the criminal organization, or they earned a greater share of the profits of the criminal scheme. And so they said, really, this is an unwarranted sentence disparity. And still, this court has repeatedly said, no, notwithstanding these claims of kind of diminished culpability relative to the cooperating co-conspirators, that's still not enough to establish an unwarranted sentence disparity. If that is the principle on direct appeal, there's no reason that that shouldn't apply with equal or greater force when we're in a post-conviction posture.
But you have no case that says that in a compassionate release, do you?
Well, this court's
Do you have
decision
the
in
case?
Melvin, yes, Melvin.
Melvin said what?
Melvin recognized that co-defendant sentence disparities did not rise
In
to
Melvin,
the level of
was
extraordinary and
that an
compelling.
affirmance of the district court?
Yes.
Right, this is
Well, you asked me
What?
for a compassionate release case,
Yeah,
and
but
that's one.
not what was granted?
No, the motion was denied, and this court affirmed the
Yeah,
denial.
give me a case where it was granted and this court reversed it.
I,
It was granted, compassionate release was granted, and this court reversed it.
I don't know of a case that this court
Exactly.
has confronted. However, I would note two published opinions from other courts of appeals that have confronted the precisely same issue, the Second Circuit in Fernandez, the Sixth Circuit in
But
Hunter.
when you say the same issue, what issue?
Co-defendant sentence disparities in a grant of compassionate release, and both of those courts reversed the grants.
Did you have the district court who tried the case helping or supporting that disparity? Like in the Judge Lee's letter, in those cases?
Those cases did not involve a letter
But
from the
this is
sentencing
extraordinary, isn't it,
judge.
that a judge would say that, trial judge, who handled the case?
So respectfully, Your Honor, the district court considered Judge Lee's letter with respect to the Booker argument, and our position remains that regardless of the personal views of the sentencing judge, it's not an extraordinary
Or
and compelling
regardless
reason.
of the views
Because
now.
even if he had to impose sentence today, he would be required to impose the mandatory life sentence. We know that
But
from
that's the whole
Robinson
point of
and
compassionate release,
Chavez.
but he doesn't have to now, because that's why we have compassionate release.
It's not a de novo resentencing, Your Honor.
It's
He
not-
has to
it's
establish
not-
extraordinary and compelling
Well,
reasons.
I think Judge Niemeyer wrote high. I mean,
Yes.
it talks about a lot of discretion of the district court. In other words, in the sense that looking at it and making a determination, you read high. Well, what limitation do you see at all in high in terms of district court's discretion? I didn't see any. Do you? None.
Use of
None.
discretion classically formulated is an
No,
arbitrary
no,
or
in terms of-
improper application.
You're trying to put a guideline now. You have no case to support it just because you don't like that, in a rare case that the judge.
That's not correct. I've cited at least
Excuse me, let me
3
ask the
cases.
question first. You now, because the court granted it, now you're trying to find guardrails, but they don't exist in the precedent of this court, of this Fourth Circuit. That's what I'm saying. And it is consideration in terms of what the person, and isn't that extraordinary in the sense that the person who's, am I wrong, that the person who killed the person, got how many years?
Eldon Brown received 60 months.
60 months. And this person got life, mandatory, right?
Yes.
And you don't think that could be the basis of a compassionate release, that the court,
Not
I mean,
in
you
this
don't
case.
think so, but there's no case law at all that says that the court is restricted from that, is it?
I offered the court 3 cases. I understand
Yeah,
that you
okay.
might disagree with them.
You're right. Again, you're here because you disagree with it, just like the other case, it was defendants that disagreed with it, but the disagreement is not enough, is it?
We maintain this was an abuse of discretion because the defendant did not meet the statutory threshold for a sentence reduction. I see that I'm over my time.
Okay, thank you.
Thank you. We ask that you reverse.
All right. We'll come down and greet counsel. Is it okay to proceed to the last case? Marvin, would you like to?
I'm good, whatever
Okay.
y'all want to do.
We'll come down, greet counsel and proceed to the last case. All right, be seated, please. The last case we'll hear this morning is United States versus Crawley. And if it were not a surprise, this is another compassionate release case. All right, Mr. Semmel, we'll hear from you.
Thank you, Your Honors. Good morning. My name is Danny Zemmel, and I'm here on behalf of the appellant, Rodney Crawley. There is one difference I wanted to note for Your Honors in this case, that we are dealing with a legal issue in this case, which makes it a little bit different than the other two. Our main contention here is that the district
Well,
court...
each case has its own circumstances, so we'll hear anything you wish to present.
Thank you, Your Honor. The district court erred in failing to recognize that Virginia common law robbery no longer qualifies as a predicate crime of violence for purposes of the sentencing guidelines career offender enhancement. In the wake of this court and the Supreme Court of Virginia's decisions in a series of cases all called U.S. v. White. This court had White 1 and White 2. Because of that change, his guidelines range would now be half, less than half actually, of what it would have been, or what it was when he was sentenced.
Let me just get to the gut of the thing.
Yes.
You make a good case. I think White, we asked the Virginia Supreme Court to certify when we were considering whether Virginia robbery was a crime of violence, and of course, as you know, it concluded that there are ways that you can commit the crime without violence, and so we have held that it's not a crime of violence. So that certainly favors you. Do you agree that we should apply Section 1B 1.13
The new amendment, yes, Your Honor.
under Davis? Yeah.
Yes, I understand that we made,
So if we apply that, it seems to me that your motion may be just a touch premature. I mean, you may be able to get it, but it seems to me you have to show that you served 10 years, you have to show an unusually long sentence, and you have to show it's grossly disparate. Now, those other two are something that the district court should be assessing, I would think. But the 10 years is, he's now served 9 years as I compute it. Maybe you give me a different number, but I recognize that his sentence has been, is affected by his good time credits, but his actual service in prison has been 9 years, and which means that to satisfy 1B 113, he should have to wait a year and come back. What do you say to that?
Oh, yes, Your Honor. I agree that under a calendar interpretation, we are at
Yeah.
9 years, and there was a supplemental briefing from us and the government on that. However, our position is that the key operative phrase here is he must have served 10 years of the term of imprisonment. The guidelines policy statement itself uses the phrase sentence, has been sentenced to multiple times. However, in this instance, it says has served at least 10 years of a term of imprisonment. And going back to Barber v. Thomas, our main argument here, a Supreme Court case that has been superseded by statute, but the logic still holds, where the Supreme Court went through that the phrase term of imprisonment is one of those odd phrases in law that can mean multiple things. And actually, in the good time credit statute itself that contains other aspects involving federal sentencing, the Supreme Court went through and noted that term of imprisonment can mean either the term to which you were sentenced by the judge, which here would be 188 months, or the amount of time you actually serve in prison, which will include good time credits. And one of the main statutes that looked at that as an example of how this can be used in multiple ways is that in 18 U.S.C. 3624, which is the statute that also
The good time credits would reduce his sentence that's imposed, right? He gets good time credits, and if he's sentenced to 20 years and he's got good time credits of 2 years, his term is 18 years, right?
Well, Your Honor, if he gains all good time credits and gets to the end, then his term, he will have served, according to the BOP, 20 years actually, because he will have served.
He will not have served 20 years. He will have served whatever time he served, but his sentence will be 18 years. He will get out in 18 years, and that's all he will have served.
Well, I think under Your Honor,
Served means he's been in prison.
yes, served
All
does,
right,
Your Honor.
and the good time credits reduces the sentence. So you're conflating the two. In this case, his sentence may be lower, but the requirement of the guideline says he has to actually serve 10 years before he can qualify on that basis.
Well, again, Your Honor, the phrase here is term of imprisonment. I think we're kind of, I understand.
Term is served. That's the verb.
It says served of the term of imprisonment. It's clarified by that, so it doesn't just say served at least 10 years. It
Sure,
could have
but he
ended
has to
there.
serve 10 years and of his term of imprisonment. Now, if his term of imprisonment is only 8 years, he can't qualify, right? Because he hasn't served 10 years.
Again, Your Honor, is our position that the term of imprisonment in the common parlance, absolutely, but it's a legal term of art in this phrase, and that the Sentencing Commission is drafting this on the background of multiple Supreme Court cases and other courts of
I'm
appeals
not
cases.
taking issue with the term of imprisonment. I'm taking issue with the fact that word served. In other words, the requirement verb is that he have served, right?
Yes, Your Honor, I think
Okay, that's my issue. Now, you can give me a case that say somebody has served 20 years in prison when he actually only served 18 years because he had good time credits. That would be an interesting case.
Well, yes, Your Honor, in the cases that we list in our brief for district courts, often in looking at compassionate release, when they talk about how much time has been served so far, they include the good time credits the person has earned so far. And part of this goes back to the actual argument in Barber v. Thomas, which is an argument about whether good time credits were basically given at the beginning of your sentence and then you can lose them, or whether you earn them along the way, and thus you're basically the amount of time you are being counted, the amount of time you spend in prison is actually extra. So basically the way the good time credit statute works, or the way we're interpreting, is that for every year you spend in prison that you have exemplary behavior, and it's not easy to gain these credits, the Bureau of Prisons essentially says you have served an extra 50 days. So we are counting more days because of the good times of your credit. The Bureau of Prisons does not have the authority to actually reduce your sentence. It has the authority to say how it's calculating you have served that sentence. And some of that can be looked at, again, I understand this gets a little bit mixed around, and I think that some of this, again, the reason we keep focusing on Barber v. Thomas is because I do agree with you, Your Honor, that under a kind of common parlance, if I were reading this not in a legal aspect, I would agree with you more so. However, based on the phrase term of imprisonment, we think is very important here because there's no other reason to have that qualifier. The sentencing policy statement could just say, has served at least 10 years. Period. And I would absolutely agree with Your Honor's interpretation. However, because that extra phrase is added, and because the Supreme Court, congressional statutes, the 10th Circuit had a whole series of cases about, in a different context, about whether or not what term of imprisonment means. And it's acknowledged that it means different things in different contexts. And further, to the extent that it is ambiguous, I think the rule of lenity would apply here. To the extent that we're saying the term of imprisonment is ambiguous, which the Supreme Court has acknowledged it is, and which even in the same statutes and similar paragraphs, it can mean different things, that in that context, it should be interpreted in favor of the criminal defendant in this instance. And we also believe that that would go to the very purpose of compassionate release. As Judge Gregory was pointing out, the point of this here is that the whole point of the statute, and especially the expansion of the First Step Act's policy, the prevention of it being gatekept by the Bureau of Prisons now being open to everyone, was an idea to look at the individual circumstances of people after they were sentenced. And the idea that people who have gotten maximum amount of good time credits would be eligible for relief slightly earlier than those who have not gotten any relief completely fits within the purpose of that statute.
Counsel, two questions. One, when you said that there had been a determination that this language is ambiguous, I think you said that just a second ago.
I said if the court determines this language is ambiguous. In other contexts, the phrase term of imprisonment has been, I apologize if I misspoke, Your Honor.
No, I may have heard you, no problem. In other contexts, term of imprisonment has been found to be ambiguous. The language serving a term, the exact language here has not. You agree?
No,
Maybe that informs us, maybe it doesn't, but the cases you're talking about aren't talking about 3624, are they?
No, and I looked again, as the government points out in the brief, I believe only one court has looked at this, a district court case from outside of the Fourth Circuit that
The
will be
second
other.
question I have, the district court didn't address this issue at all, correct?
No, Your Honor, it did not.
So we're doing something on our own for the first time here. I mean, we could do that, it's a legal issue, maybe we could, but we're not reviewing anything on this point at all. The only thing the district court ruled on is the light issue, correct?
Yes, Your Honor. And so the policy statement, I think some of that could just be because of the timing aspect of it. This statement came out after all the briefing had been done and before the district court issued its opinion, but
Well,
yes.
That wasn't a criticism
Yeah.
of the district court, it's just,
And
we
so in our,
usually do things and look at what others do and not do them ourselves, and, we don't always do that, so we can decide. I just wanted to make sure I understood the procedural background.
yes, Your Honor, the court, as I read the district court's opinion, it did note that this policy statement had been introduced, but did not address it. That's how I read the court's opinion. And that does bring me into one other point on that if this court disagrees with my interpretation, our interpretation of the term of imprisonment rule, we would still ask that this court rule on the crime of violence with the U.S. v. White. Because as Judge Niemeyer pointed out, even if the government is correct on the 10-year rule application, we're basically saying not that Mr. Crawley is ineligible for relief, but that he has to wait a little bit longer. And given that this is a pure legal issue of whether or not
Is
White.
there a question about White? I thought we had that pretty well settled, didn't we?
I thought as well, Your Honor, but the court said here that it said it was uncertain, but it didn't recognize the reality that he would no longer be a career offender now. And so at the very least, the district court needs to be corrected on that point and made sure that going forward, what the district court pointed out was that technically White dealt with the Armed Career Criminal Act, whereas in here we're dealing with the sentencing guidelines, and they have different enumerated offenses. The problem is that the definition to meet categorically the enumerated offense, you have the same force clause issued. So this court's holding is binding, but the district court said specifically that it
I
couldn't be
understand
certain.
the question, yes.
Yeah, and so that is our position on that. And then,
Why wouldn't we, counsel, why wouldn't we say White says this is not a crime of violence, we vacate, district court, look at the situation and, deal with this, time served in the first instance, and we deal with it if it, depending on what happens.
yes, this court definitely
It
has.
may be that he served the full 10 years without any credit by then, and we'd be dealing with an issue that, is not even necessarily right for us.
Yeah, I mean, your honors definitely have the authority to do that, to, kick this back to the district court and have them look at this in the first instance. Our position here is that this is a purely legal issue that this court can address, and that, also going to the timing aspect as a practical matter, that, our position as well is that, Mr. Crawley, currently, if he does show the extraordinary compelling sentences, he has now served, regardless of how you interpret that term, he has served more time than the maximum of the guidelines would be now. For someone that at the sentencing hearing itself, the district court in that case said, this is a long sentence, I hope something happens, I hope this can release this for you, things like that. And so to a certain extent, the longer that this process pushes out, he ends up serving a much longer sentence for that purpose. So in a certain sense, in the sense of getting a merit on that, we are asking for this court to rule on the legal issues that are in front of it, but there is certainly the authority for this court to correct the district court on the crime of violence issue, which is the main one we are pushing, and have the district court look at the 10-year rule in the first instance. And so if this court has no other questions at this time, I'll reserve the rest of my
All right,
time for
thank you,
rebuttal.
Mr. Zemmel.
Thank you.
All right, Mr. Honnold?
Good morning, and may it please the court. Daniel Honnold for the United States. This court should affirm because the district court did not abuse its discretion in denying defendants' request for compassionate release in this case. I think probably the simplest way to get there, as we were discussing this morning, both parties agree that the 1B 1.13 policy statement should have applied and does continue to apply at the time that the district court adjudicated this motion. The upshot of that is that the defendant needed to have served 10 years at the time the district court decided the motion. It's quite clear based on the plain language of the policy statement that he did not. In fact,
You would say, I'm having trouble understanding your lack of use of discretion argument. I can understand you saying there's an independent basis to affirm, namely that he hadn't served 10 years based on how this language is interpreted. But, the district court, if there's an alternative basis to affirm, that's not the same as saying there was no abuse of discretion in the White interpretation. Does that make sense?
I understand your point, Your Honor. We do have arguments on White that directly go to the abuse of discretion.
Okay.
I agree with your framing that this is maybe possibly better considered as an alternative grounds for affirmance, and it's one that this court should assess in the first instance for two basic reasons. The term has served at least 10 years is a term of art that this court can construe and would be a legal issue that would be entitled to no deference in the district court, so the court can just address it in the first instance in its discretion. And it's dispositive of the case. All parties agree that at the time of the motion, the defendant had served well short of 10 years. And so the only way to get to 10 years is by some sort of interpretation by which has served 10 years would need to also incorporate good time credits.
How many years has he served as of now?
Approximately 9 years, Your Honor. And at the time of the adjudication of the motion, it was a little bit over 8 years. And so the way that the defendant tries to get there is through this Barbara v. Thomas case and an interpretation of 18 U.S.C. 3624. But that case deals with the vesting of good time credits, which actually supports our position. I think it's beyond dispute that these good time credits are accrued at the end of each calendar year at the anniversary of an inmate's term of incarceration. But they do not vest until the end of someone's sentence, meaning that they can be removed and taken away at any time for disciplinary infractions, for other reasons, of course within, the bounds of reason. But the very fact that they can be taken away means that they cannot, under any plain language understanding of the term has served, be something that somebody has served. And just to give sort of a more commonsensical example, if two inmates are, meeting each other for the first time in jail, one turns to the other and says, how much time have you served? How much time have you been in? If a person has been in jail for 2 years, they would turn to the other person and say, I've been in for 2 years. They wouldn't say, I've been in for 2 years plus 108 days because I've got 108 days of First Step Act credits. That's not how people talk. That's not how anybody would understand this term. And the fact that it's directed towards the past, has served, it's a backwards-looking analysis. It's not how much time will be shaved off the end of my sentence. It's how much time have I been in jail. That is, I think, the only natural way to understand it. And on that understanding, given that we're operating on an agreed sense that we're going to be using the policy statement, that's going to dispose of this case. A district court would not have had the ability to grant compassionate release
What's your
under
view
B6.
on White?
Your Honor, the court's view on White, taking a step back, we are viewing this in the context of a compassionate release motion. And so the court is considering whether a change in the legal landscape can constitute an extraordinary and compelling reason. What the district court does here is note, and I think fairly, some residual uncertainty about whether or not
I
Virginia
understand that.
robbery.
That's why I asked you the question, is what's your position on White? In other words, White, what was White, ACCA?
White was an ACCA case, Your Honor,
Okay.
and so was Williams.
And this is a guidelines case?
This is a guidelines case.
Okay.
And
So
that's
now the
important.
question is, would White govern in this circumstance? What's your position on that?
White does not control. I don't think anybody really argues that White controls the issue for a couple of different reasons. As Your Honor pointed out, White was an ACCA case, and ACCA does not have enumerated robbery. The guidelines do. And so White never had the occasion to address whether or not Virginia robbery.
The guidelines enumerates robbery, and that's really not at issue. The question is, the robbery that's understood in the guidelines, does that include a Virginia robbery which doesn't, which can be committed without violence?
It can be, so the only problem under White and Williams with Virginia robbery is that it can theoretically be committed under the sodomy threat theory.
Right.
That's the only problem with Virginia robbery for purposes
Well,
of
it's not the
force
only
clause.
problem, it's a material problem to whether it's a crime of violence, right?
It's a material problem to whether it's a crime of violence under the force clause. But whether or not something is a categorical match to either generic robbery or the guidelines definition of robbery is a separate legal analysis that this court, and to my awareness, no court has
Does the
undertaken.
guidelines define robbery?
It does now, Your Honor, and that's my second point, is
And
that
how's it define robbery?
it is defined as of the 2023 version of the guidelines. It's a bit of a lengthy definition, but I can read it for Your Honor if you want.
Is
It's
it
at
your
4B1.
position, I'm sorry to cut you off before fully answering Judge Niemeyer's question, but is it the government's position that robbery by threat of sodomy is encompassed by the guidelines definition of murder?
Our fundamental submission is that we don't know. No one has undertaken the task of trying to analyze it, either
What
below
would-
or on appeal.
What's your
We
position?
got no case on it, but how would you articulate that it is?
Your Honor, a court assessing the issue would have to look at either generic robbery or the guidelines definition of robbery, again, which no party has cited to or discussed, much less the district court. So,
I guess my question to you, and I think Judge Quattlebaum's question is, do you have a position as to whether the guidelines definition covers Virginia robbery?
we haven't taken a position on that. I think
Well,
that would.
shouldn't you have to in this case?
No, Your Honor, because as we've said, there are there's an alternate grounds for affirmance here.
Well,
And
you
I
didn't-
understand,
But that wasn't discussed below, was it?
no, Your Honor, but it's quite clear what the bar is here. When we're talking about whether or not an inmate has served 10 years, we can all add up to 10 and we all agree.
If White doesn't control us, we should affirm the district court. District court made and we wouldn't go to an alternative ground. I guess we could, but anyway, it seems like, the first, natural first step is to look at what the district court did. And the district court said it couldn't tell, I don't remember the exact language, but it basically, found a crime of violence. And so we need to, am I missing, you're shaking your head like I'm.
I apologize for shaking my head in the middle.
If I'm wrong, shake away.
So what the district court held is that it was uncertain. It came to the conclusion that it was uncertain whether or not Virginia robbery met the enumerated robbery
Right.
definition in the guidelines.
Why did it deny compassionate release?
Why did it deny compassionate release? It found that residual uncertainty paired with the other proffered reasons, which were COVID-19, which defendant abandons on appeal, and rehabilitation, the combination of those three factors, even considered together, did not in its discretion amount to an extraordinary and compelling circumstance. So I understand the court's point, like maybe this is the more natural way to just assess it on the merits first, but the court has the discretion to tackle these issues in whatever order it feels appropriate. And here we've got a pretty clear, like math-based reason to affirm and to say that the court could not have granted relief and therefore it should affirm. Whether or not, it could get into the issues if it wanted to about whether or not White, controls and the status of Virginia robbery as a crime of violence. But frankly, those are stickier issues that haven't really been fully briefed up given the amendment to the definition of robbery in the guidelines. So we would just submit that the easier path is the way to go here. And if the court does decide to affirm on the basis that defendant hasn't served 10 years, which he has not, there's no real reason to go into White. That can be left for the district court in the first instance or for a future case. That would be kind of trending towards potentially an advisory opinion on a non-dispositive issue.
I'm just looking at the definition and the guideline. It said you're taking the property from another on a threatened fear of injury. And the question is, I guess, to threaten somebody with sodomy, would that be a threat of injury? I don't know whether the argument is reputational injury or whatever is possible under that. I do see there's might be some interpretive difficulty. I don't know.
Exactly, and that's our point, Your Honor, is that it is a tough question. And so basically, that cashes out in two ways. One, it was reasonable for the district court to note that difficulty, and two, when there's an easier way to affirm, this court should likely take that path. Your Honor, we have other arguments about why a White claim wouldn't be properly considered an extraordinary and compelling reason, even if Virginia robbery were not to be found to be a categorical match to enumerated robbery. I'm happy to address that if the court's curious about that. We would also suggest, my friend at the end of his opening brief asked this court to essentially grant compassionate release instead of remanding the case.
Never mind.
And Your Honor, the only thing I'd just say, we talk about the serving the 10 years in the context of subsection B6. That's really the only possibly applicable subsection of 1B1.13 that could apply. My friend briefly mentions the catch-all provision, but subsection C of the policy statement very clearly says that changes in the law cannot be considered anywhere else other than B6. And so if B6 doesn't apply, the catch-all provision is also not going to apply because the only thing he identifies now is rehabilitation, which is not alone sufficient, and a change in the law. And so for those reasons, Your Honor, we'd ask that you affirm the district court's denial of this motion for compassionate release. If there are no further questions, I'll take my seat.
What's the status of his service of his prison term?
Your Honor, so as of today, he has served approximately 9 years.
And under current circumstances, his good time credits don't merit his release yet.
Not yet.
He has
His-
188 months under current status, right?
That's correct.
And so he's served roughly 109 months.
I haven't done it in months, and I hate to do
All right.
I would hesitate to do the mental
Never mind,
math,
this is
but
just
it's,
speculation. Thank you.
yes, Your Honor. If I could just
Yes.
give a more concrete answer. According to the BOP, his projected release date is in June of 2029, with an additional 365 days of First Step Act credits. It would be in June of 2028, so several years from now.
Okay,
Thank
thank you.
you.
That's helpful.
Did I get the remainder of time? A few things, Your Honor. One, I wanted to just go quickly on the White issue and the 10-year rule issue separately. First of all, on White, I just wanted to point out that the generic definition of robbery was briefed in this instance, and the generic definition of robbery under the guidelines is not materially different from what this court used in U.S. v. Gaddis. The main fight over the generic definition of robbery, as this court is probably well aware of, I believe Judge Niemeyer Your Honor wrote Gaddis more than I am, is about the level of force that was necessary. There's a lot of argument about threat of force to property and things like that. There's never been a debate that some sort of threat of force to person or property is necessary. I think it's also worth noting that the Supreme Court of Virginia is the one who defined robbery differently here. We're not talking about Fourth Circuit precedent. We're talking about respect for state law definition of what their robbery crime is. And I believe that, as our position is, the district court's statement of uncertainty on a legal question does not matter. Whether the court says you were wrong or right about a legal question, or I don't know the answer to a legal question. If the answer to a legal question is yes, and the court says no or I don't know, that is still a legal error that constitutes an abuse of discretion. And it's impossible to separate the district court's denial of the extraordinary and compelling reasons from its belief that White still
Well, I
might.
would think the burden would be on you under a motion for compassionate release to show a change in the law.
Yes, Your Honor. And so it's our position, though,
And
that
you
if.
would have to carry the burden on that, right?
Yes, Your Honor, but that whether or not the law has changed is a legal question. And so the fact that the district, so this court can review that de novo. It is not, if the district court had said, yes, the law has changed, but your factors don't meet, or whatever the other analysis, that's an abuse of discretion land. Here, the court denied that there was even a change of law in the first place. And the fact that it said uncertainty, it expressed uncertainty on the legal question, that does not matter. I think the confusion comes in that if it had said there was a change in law, but I am uncertain about whether you are granted relief because of that, that is an abuse of discretion. That is a discretionary
As a
standard.
matter of fact, the district court said, I'm not sure Virginia, how they defined it. I mean, he was unsure they had done that.
Yes, Your Honor. And so I think that's, and so that is an answer. And I wanted to quickly go to the 10-year rule thing on a few more things. I don't want to repeat what I said before, but I think it's worth noting that my friend on the other side kept saying time served, time served, time served. It's of the term of imprisonment. That phrase cannot be written out of the policy
Well,
statement.
you can only serve a term of imprisonment. We're not serving cocktails.
Yes, but sentence and other things, so
So
there's,
in order to make the sentence clear, you have to serve 10 years of your term of imprisonment.
but they use other phrases in other contexts, Your Honor. They say serve the sentence, or has served 10 years of their sentence, or the term of
The term
imprisonment
of
to which they
imprisonment
were
or your
sentenced.
sentence, I'm not sure that's a big deal, but.
Well, Your Honor, that is, but the other thing I wanted to note on the good time credits is that again, the district courts, and I don't have all the names off the top of my head, but they are in our brief. Many district courts here, within the Fourth Circuit, and that this court has affirmed, have said that when they're granting relief, something like, the defendant has served 140 months counting time, good time credits. They don't say, that the good time credits, which they may lose in the future, that's a speculative nature. The same way we cannot count good time credits he hasn't earned yet, they cannot speculate that he might lose them, because it's worth noting under this court's precedent, they cannot be removed willy-nilly. They are earned each year. So there's a lower bar for removing the ones that you haven't earned yet of that year. But once they are earned, it requires pretty serious infractions and procedural due process protections for them to be removed. And so as a practical matter, too, on the good time credits, most of the issues that would involve Mr. Crawley potentially losing those good time credits would separately be things that would deny him compassionate release anyway. If he commits kind of serious infractions like that. Your Honors, I believe I've reserved more time before, but it looks like I am out of time. So I would like to ask that you reverse the district court. Thank you.
Thank you. Mr. Zemmel, you were court appointed, were you?
Yes, Your Honor.
We really appreciate it. I want to recognize your service to the court. It's, as you know, it's an essential function of our court to have somebody like you doing this and doing a good job. Thank you very much.
Thank you very much,
We'll come
Your Honor.
down and greet counsel and adjourn for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.